Oh, okay. Is this your son?
Yes.
All right. Hey, what's your name?
You can tell him your name.
All right, what's your name, sir?
Johnny.
Johnny. All right. All right, Johnny, where you coming from?
Just walking around.
Just walking around?
Yeah.
All right, enjoying this weather?
Yeah.
Gotcha. Well, we're checking up on you, man. You know?
Just walk around. What the heck is this deal?
Found it a little bit suspicious, you know? So,
What?
just walking around.
Walking around is a little bit suspicious?
I mean, technically not really, but I mean, it is pretty early in the morning. Just wondering what was going on.
That's what we do. We get up early in the morning.
You got your ID on you?
What do I need an ID for?
Because I just asked you for it.
I don't need to show my ID.
Okay, if you don't give me your ID, I'm going to take you to jail for failure to identify because I've identified that you've been walking around down here at 5:30 in the morning.
Yeah, we do that.
No, you're not. Give me your ID.
I don't have my ID on me because it's at the house.
Okay, what's your name and date of birth?
Huh?
What's your name and date
I
of
don't know, but you can't run. I don't have. This is a state where I don't have to show my ID.
Turn around.
You're gonna do this in front of my son?
birth? Yeah, turn around.
Are you serious?
Yeah, turn
This
around.
is my son. Let me bring my son home first.
No, turn around now.
Bro, you need here. Let me videotape this real quick. I want this on video. What are you doing to my son? Bro, this is up. Son, it's okay, okay?
It's good.
Bro, I promise you, you're gonna pay for this.
You think?
Yeah, I promise you that. We're walking around. There's nothing suspicious. I've done nothing criminal. I don't have my ID on me. I told you that.
And what did I tell you?
And you just slammed me on the ground because I was trying to record. What are you rolling me on the ground for?
It's gonna be okay.
Dude, this is ridiculous. Man, look what you're doing to my son. There's my phone right there, too. You're a punk. You know that? Dude, I can't even believe you're doing this to my son because we was walking around on 4th of July.
Have a seat and I'll talk to you. Hey, buddy, come here. You're okay. Listen to me. You're okay. Hey, quit crying. People that don't want to identify typically are involved in criminal activity. I've known this individual to be involved in thefts in the city of Canton.
There has been no criminal activity.
Okay, listen to me.
Bro, we were just walking, and when you
Okay.
came up,
So listen.
you didn't hear what he said
Shut
when
up
he first
and
came up,
listen
though,
for a
did
minute.
you?
No, shut up and
Okay,
listen.
what?
Okay. So I saw y'all walk down the alley behind the... I saw y'all when I was headed into the office. Walk down, walk across the street.
Yes, sir.
Then I got my unit ready. While getting my unit ready, man, I see y'all back in the alley you left from, okay?
We walk from that alley around. That's
Okay.
our house is around that. Is that why we do that? I promise. We do it every morning. I'm surprised you haven't seen me.
So here's the thing. That's fine and dandy, man. But listen, we have people that are going down up and down these alleys, spray painting and tearing shit up.
Yes, sir. I understand that.
Okay? It's the 4th of July, man.
But
Okay,
if he
no,
would
no,
have
listen,
came up and said
stop,
something like,
stop.
"Hey," but he just goes,
Hey.
"I've been called for what do you say? Investigation of something." And I'm like, "What?"
Yeah, okay, so here's the deal, though. Listen, when I got there, I didn't play games with you. I asked you what y'all were doing. You said, okay. I've worked here. Yeah, and that's fine, dude. I love it that you're out with your kid. But it is a little odd, okay? So when I ask you for your ID, you say, I don't have any ID. So what's your name and date of birth? That's all you have to give me. Give me your name and date of birth. What is your name and date of birth?
I know, but it's just because
No, this is your last opportunity.
You're asking me right now? I thought you were saying my name is John.
Officer Goodwin argues that he is authorized to demand identification from Mr. Sexton because he was walking in an alley early in the morning where there had been prior vandalism incidents. Oklahoma does not have a stop and identify statute that requires citizens to identify themselves to police officers. However, Section 21 to 540 of the Oklahoma statute states that, quote, any person who willfully delays or obstructs any public officer in the discharge or attempt to discharge any duty of his or her office is guilty of a misdemeanor. And as this statute does not require physical obstruction in order to sustain a conviction, It is conceivable that an individual could be charged with obstruction for refusing to identify themselves under certain circumstances. Although I could not find any court cases involving such a criminal charge under this statute, nonetheless, the Supreme Court has made it abundantly clear that the Fourth Amendment only permits officers to demand identification under threat of arrest if they have reasonable suspicion of criminal activity. For instance, in the 1979 case of Brown v. Texas, the Supreme Court held that it violated the Fourth Amendment to detain an individual and require him to identify himself when officers lacked any reasonable suspicion to believe that he was engaged in criminal conduct. In the case of Brown v. Texas, officers detained a man that they saw walking in the opposite direction from another man in an alley, in an area with a high incidence of drug traffic, because the situation quote-unquote looked suspicious, and the officers had never seen the quote-unquote suspect in the area before. In concluding that detaining and then arresting the man for refusing to identify himself violated the Fourth Amendment, the court reasoned that, quote, none of the circumstances preceding the officer's detention of appellant justified a reasonable suspicion that he was involved in criminal conduct. The court noted that the officer testified that the situation in the alley quote-unquote looked suspicious, but then concluded that, quote, he was unable to point to any facts supporting that conclusion. There is no indication in the record that it was unusual for people to be in the alley. The fact that appellant was in a neighborhood frequented by drug users, standing alone, is not a basis for concluding that appellant himself was engaged in criminal conduct. In short, the appellant's activity was no different from the activity of other pedestrians in that neighborhood. Now, here while Officer Goodwin pointed to previous vandalism incidents in the area, there were no facts showing that Mr. Sexton was potentially involved in that activity, as he clearly did not have any spray paint on his person, and there was no evidence to suggest that he was doing anything other than taking a walk with his son. As such, it is highly likely that a court would conclude that Officer Goodwin did not have the reasonable suspicion necessary to detain and identify Mr. Sexton. Reasonable suspicion can be a complicated concept, as can many other legal issues surrounding police encounters. If you would like to learn more about how to effectively navigate police encounters, well, then you may want to pick up a copy of the Civilian Rights Hand Guide, our comprehensive guide to officer interactions. In the first half of the book, we explore the underlying constitutional principles involved in police encounters. Then we provide practical step-by-step tips for managing various types of officer interactions, so you can understand how to effectively assert your rights in any situation. The Civilian Rights Hand Guide is available exclusively on Amazon, and you can find a link in the description and the pinned comment down below. Thank you so much for your support, and now let us continue with this interaction.
Tonga 5 Weatherford, show 1 detained. Okay, listen, man, as long as you don't have like a bad warrant, I don't want to take you to jail. I don't like taking people to jail. I don't like doing what I had to do to you in front of your kids. But you caused it. All you had to do was provide the information asked. Listen, shut up and listen just a minute. We had reasonable enough suspicion to identify you. That's all that matters.
But if I did criminal activity.
Yeah.
But I didn't do no criminal activity.
Yeah.
No, I didn't. I didn't do nothing criminal walking with my son.
Okay. It's not criminal, but we still have reasonable enough suspicion to identify you.
And if I want to give the ID, I can.
No, it's not a if. The state is not a if you want to
so
state.
It's a state that they can ID you at any time.
It's not a. This is not a shall ID state. But once you're being detained,
what was I being detained for?
Criminal. Like we don't know what's going on, but we can call it criminal activity.
That's not. But I didn't do criminal activity, sir. That was
okay, man.
Thrown down like that in front of my son.
I didn't even throw you down. If you want to know the truth.
You did. And
no.
You rolled me on the ground, sir.
I rolled you on the ground to.
2 times.
I just making sure you don't have any weapons in there, bro.
Bro, that was just a little overdoing it when a kid's right there. Is all I'm saying.
Well, don't you think maybe next time a cop says, "Hey, what's your name?"
I don't have my ID though. That's what I was telling you. I don't have it on me.
But I did ask you what your name and date of birth is. I'm not going to sit here and argue with you about it, Mr. Sexton. Okay, you got warrants out of, see? And that's what I was saying, man.
Where at?
I've been doing this. You got warrants out of Woods County.
They don't pick me up. I was just
Okay, but here's the thing, man.
It's a ticket, that unpaid ticket.
But here's the thing, man. Typically, when a cop's out with somebody and they don't want to identify, it leads us to believe that you are involved in more criminal activity than we need to. So that's why you heard me saying what I was saying, because I'm narrating for the camera. This is not my first day on the job, okay? If I tell you to do something, you better be doing it. Does that make sense?
Yeah, it makes sense, but
hey, you know what? Maybe teach.
I don't have to do. You know what I'm saying? Like, I just thought
just
my son being there, it wasn't the right time to do all this.
Yeah, well, you know what, man? At 5:30 in the morning.
Bro, I get up 4 o'clock every morning.
No, that's cool, man.
4 o'clock at night. I get up at 4 o'clock.
But put yourself in our position. Our job is to make certain that it's not going on down here. We see all the spray painting. So I literally saw y'all cross right here.
Indians around here running around doing that bull.
I got you, bro. Was clear. How you getting along over there, boss? Huh? Yeah. He's got possible warrants. So when I was headed in, I saw him walk down the alley, and then when I moved my truck around to the covered stuff, you know you can park back there if you want, right?
No, I didn't know.
Yeah, you can, man. When I moved my truck back around there, like I turned, so this is Prouty. They were already walking out of the alley at Noble. And they walked, and then they just turned around, and he went right back into the same alley he came from. And he was hanging around on it'd be like 101, 102 or something like that. I'd have to go back and look at the address. But he's hanging around back there where they cook all that barbecue and stuff. So that's why we're making contact with him.
Yeah.
When people don't want to identify, typically.
Officer Goodwin repeatedly claims that when people refuse to identify themselves, it is because they are involved in criminal activity. However, citizens have the constitutional right to refuse to identify themselves during consensual encounters with the police when they are not suspected of criminal activity. And the Supreme Court has repeatedly made it clear that declining to answer an officer's questions cannot, without more, create the reasonable suspicion necessary to justify a seizure. For instance, in the 1983 case of Florida versus Royer, the Supreme Court stated that, quote, law enforcement officers do not violate the Fourth Amendment by merely approaching an individual on the street or in another public place, by asking him if he is willing to answer some questions, by putting questions to him, if the person is willing to listen, or by offering in evidence in a criminal prosecution his voluntary answers to such questions. The person approached, however, need not answer any question put to him. Indeed, he may decline to listen to the questions at all and may go on his way. He may not be detained even momentarily, without reasonable objective grounds for doing so, and his refusal to listen or answer does not without more furnish those grounds. Likewise, in the 1991 case of Florida versus Bostic, the court noted that, quote, a refusal to cooperate without more does not furnish the minimal level of objective justification needed for a detention or seizure. Accordingly, a court would almost certainly conclude that Mr. Sexton's refusal to identify himself did not create reasonable suspicion that he was engaged in criminal conduct, as he had the right to refuse to cooperate with Officer Goodwin's request for his consensual cooperation.
Too early for this.
He was like 10.
Huh?
He might have one, he's down like 10.
Yeah. He didn't want to identify. He got his tripped up, put on the ground.
What was he doing?
So when I came in, I come from the north, I see him cross this street, Prouty, in the alleyway. He's walking down. When I turn to go put my stuff up, they don't come out at Noble. I get my stuff to go, and I move my pickup around back, and they're hanging around like the back over there, where the bar, like where TGC is and stuff. They're hanging around over there. I don't know what they're doing. So Joaquin finds him. Joaquin's talking to him. He's like, I don't have to tell y'all anything. I said, dude, it's like, you're being detained. Hold on. I said, you give me your ID. He's like, I ain't giving you my ID. I don't have it. I said, okay, what's your name and date of birth? And he said, I don't have to tell you, or something like that. So So I said, all right, go ahead, turn and put your hands behind your back. I'll take you in for failure to identify. Like, you're being detained. Like, I don't know. I was fixing to tell Joaquin, like, you know, if we can kind of get the situation where we can go over there to TGC and see what's going on and make sure nothing's out of the ordinary. He's like, we're just out walking, man. We walk every day. Okay, that's cool. But how much crap goes on in these alleys, Jarrett?
Yeah, right. Yeah, right.
So, he wouldn't turn around and put his hands behind his back. So he got the old jerk, kick your feet out from underneath you right in front of his kid. I hate to be that way. 4th of July, you know what I mean?
Officer Goodwin admits to his fellow officer that he kicked Mr. Sexton's feet out from under him despite previously telling Mr. Sexton that he did not throw him down. I didn't even throw you down. If you want to know the truth, you did, and me on the ground, sir. As we have discussed many times before here on ATA, whether an officer's use of force is constitutionally quote, unquote excessive under the 4th Amendment is governed by the 1989 case of Graham versus Connor, where the Supreme Court determined that claims of excessive force by law enforcement should be analyzed under the 4th Amendment so-called objective reasonableness standard and established 3 factors for courts to consider when determining the constitutionality of a use of force: the severity of the suspected crime, whether the suspect posed an immediate threat, and whether the suspect was actively resisting or attempting to flee. Now, it should be noted that while it is likely that a court would conclude that Officer Goodwin did not have the necessary probable cause to arrest or even the necessary reasonable suspicion to detain Mr. Sexton, as the 10th Circuit Court of Appeals explained in the 2007 case of Cortez versus McCauley, quote, the excessive force inquiry evaluates the use of force used in a given arrest or detention against the force reasonably necessary to effect a lawful arrest or detention under the circumstances of the case. Thus, in a case where police effect an arrest without probable cause or a detention without reasonable suspicion, but use no more force than would have been reasonably necessary if the arrest or the detention were warranted, the plaintiff has a claim for unlawful arrest or detention, but not an additional claim for excessive force. In other words, to determine whether Officer Goodwin's use of force was constitutionally excessive, we must assume that he had probable cause to arrest Mr. Sexton for refusing to identify himself, and then determine whether the force he used would be excessive under those circumstances. So, applying the Graham factors to this situation, Mr. Sexton was suspected of at most a nonviolent misdemeanor, and there was no evidence to suggest that he posed any sort of physical threat to the officers or anyone else. And while Mr. Stahn did refuse several orders to quote-unquote turn around and arguably passively quote-unquote resisted arrest by taking a few steps back from Officer Goodwin, he did not outright flee, actively resist arrest, or physically fight Officer Goodwin in any way. And Officer Goodwin did not attempt to use any intermediate levels of force before throwing him to the ground. As such, Mr. Sexton would have a strong argument that in addition to not being justified by reasonable suspicion or probable cause, the force used against him was also quote-unquote objectively reasonable and therefore quote-unquote excessive under the 4th Amendment.
Says he gets up every morning at 4 and walks around. You ever seen him?
No.
Me neither.
No, and I call out those when I do them too.
Yeah.
I purposely drive behind them.
I don't think I'm out of the scope of my job, do you?
No. I mean, we've been told to extra patrol because of issues in the alleys, and now we're checking out somebody that's
Yeah, exactly.
We've got break-ins, we've got graffiti, reports of drug stuff.
He's got warrants out of Woods, Custer, Case. Yeah. This guy, he had weed in his car, a little bit of weed, but not enough to matter. You know this guy at all?
The name sounds familiar, but I don't.
Is this the guy that Travis got into it with at Canton? Is this the coins, the guy that stole the coin jar off the Buzz player? Okay, man, have a good night. See? I'm not dumb, am I? People usually have warrants that don't want to identify.
I know, but they've been on there for 10 years. Like, they're just for tickets.
Okay.
That's all they are.
Well, here's the thing, though. Are you aware of what they're doing now? So now that I've advised you, they're all supposed to put a check mark on them or whatever. So the next time somebody checks out with you, guess what? There's a good chance you might go to jail for them. So you might want to start getting a hold of them counties and take care of it.
Yeah, you got to get a hold of them now, they say. They used to just put warrants out, but they said if you get a hold of them and you can't pay it, they'll work with you and not put one out. But
yeah, but here's the deal.
This was from 10 years ago. That's the reason
a lot of you guys have strung them out so long now that they're saying, hey, guess what?
Sit them out.
Nope, yep, you can come set them out.
Yeah.
All right, man. Mr. Sexton, if you're going to be walking around, that's fine, but we've literally been put on extra patrol in the alleyways, so that's why you got checked out with. And if me or one of my officers check out with you, at least give them your information. Okay?
All right.
So you guys have a good day.
You got my phone?
Yeah, I do. Glad you asked. I'd had to try to come find you. Where are you working at?
Apple Market.
Okay, man. Hey, buddy. See, this is what we don't.
Come on, son.
Hey.
You're supposed to be in there, son. Come on. You can't play in there. That's not ours, okay? We'll go home and pay.
All right, so listen, you guys, we don't mind you getting out and walking around, but when the police officers ask you who you are, you better tell them, okay?
Mr. Sexton eventually obtained body camera footage of the encounter, and he created a TikTok account to share the video. It went viral, resulting in an influx of complaints from local residents and social media activists alike, and local residents organized meetings to address their grievances, including a demand for the replacement of the city manager, leading to the resignation of both the mayor and vice mayor. Additionally, after Mr. Sexton's interaction went viral, another Watonga resident came forward with an allegation regarding Officer Goodwin punching her autistic 15-year-old son 3 times after her son bit him. It has also come to light that before Officer Goodwin worked for the Watonga PD, he was employed as a deputy with the Blaine County Sheriff's Office. Sheriff Travis Doherty told the media that Goodwin was demoted and eventually left the department after receiving complaints from deputies who he supervised. After the encounter, Mr. Stahn filed a complaint against Officer Montoya and Officer Goodwin. The Oklahoma State Bureau of Investigation looked into the complaint and then privately turned over its findings to the district attorney. Prosecutors declined to file criminal charges, but the Watonga Police Department terminated Officer Goodwin after conducting its own disciplinary review. However, in November of 2024, Officer Goodwin was reinstated after he appealed his termination. Mr. Stahn has retained an attorney and has indicated that he intends to pursue a civil lawsuit. Overall, Officer Goodwin gets an F for detaining and demanding ID from Mr. Sexton for no legitimate reason, maintaining a hostile and confrontational demeanor throughout the encounter, and for slamming Mr. Sexton to the ground for not complying with his legally questionable orders. From the moment that Officer Goodwin arrived on the scene, he insisted that he had the authority to detain and identify Mr. Sexton, despite having no evidence of any criminal activity or even attempting a legitimate investigation into Mr. Stahn's conduct. Officer Goodwin based his entire investigation on the misunderstanding that simply being in a high-crime area fulfilled the reasonable suspicion standard. But the Supreme Court has explicitly ruled the opposite in the Brown case that we discussed earlier. Officer Goodwin also implied that people who don't want to identify themselves are likely criminals, or that, quote-unquote, there's something else going on. However, this assertion is not just wrong. It is also harmful, legally unsound, and incompatible with the fundamental principles of a free society. When law enforcement labels a citizen as quote-unquote suspicious solely because they asserted their right not to identify themselves, it undermines the very freedoms that the Constitution seeks to protect. This mindset encourages officers to operate from a presumption of guilt rather than innocence and penalizes citizens who are knowledgeable about their rights. Overcoming this stereotype is one of the greatest challenges facing law enforcement culture today. And this interaction highlights the fear and resentment toward officers that this conduct fosters. Officer Goodwin went on to assert several other misinterpretations of the law, and then eventually escalated this encounter into a physical altercation and likely unlawful detention. Based purely on this interaction alone, I find it incredibly troubling that Officer Goodwin was reinstated after such an egregious display of ignorance, incompetence, and unprofessionalism. Mr. Sexton gets an A+ because although he may have benefited from less talking, he remained relatively calm and collected throughout the encounter, politely refused to surrender his ID, and followed up this interaction by acquiring the body cam footage and finding legal representation. For most citizens, being arrested in front of your child during your routine morning walk would evoke a strong emotional response. but Mr. Sexton remained extremely calm considering the circumstances. Mr. Sexton voiced his dissent without becoming enraged or vulgar, and although he did briefly step away from Officer Goodwin, he ultimately complied with the officers without physically resisting. Mr. Stahn also took it upon himself to request the body cam footage after the incident and filed a formal complaint that led to Officer Goodwin's initial termination and the resignation of other city leaders. While it is unfortunate that Officer Goodwin was able to get his job back, Mr. Stahn now has an attorney and intends to file a lawsuit. I commend Mr. Stahn for keeping his composure during the interaction and for doing everything in his power to hold the officers accountable afterwards. I will be sure to keep you updated on the status of his lawsuit in a future update episode. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to pick up your copy of the Civilian Rights Hand Guide in the links below.